Number 66, matter of Karlin v. Stanford.
Good afternoon, and may it please the court. Christina Natesy for appellant Daniel Karlin. May it please reserve 3 minutes for rebuttal?
Yes.
Thank you. Appellant Daniel Karlin challenges as unconstitutional under the First Amendment a parole condition which banned him from viewing, accessing, possessing, or downloading any materials depicting any sexual activity, nudity, or erotic images. The condition is not limited to pornography. It has no carve-outs. It allows for no exceptions.
The condition is limited to that computer, correct?
No, Your Honor, it's
To a
not.
computer.
It's, the condition was implemented when Mr. Karlin received access to a computer, but it applies to any material that he accesses through any means.
So
He asks
he
for
can't-
it.
He can't go to the movies? Are you saying that's part of his condition and watch whatever he wants to watch or listen to explicit music?
Television.
My understanding of the condition is that it applied to any,
And where is that in the record?
well, the condition itself is not limited in language to any material that Mr. Karlin accesses through the internet.
Well, the condition came up when he asked for a computer that he needed for work, and they gave him a sheet, and I think it's, I don't know how many, 8 or 9 requirements that all have to do with a computer, and the last one is this one, which you're challenging, which also has to do with a computer. So it's safe to assume that it has to do with computers, no?
Mr. Karlin's assumption is not that it's limited to anything that he accesses through the internet, but regardless.
And what does he specifically assert there were things he actually did not do because of this condition?
So Mr. Karlin is subject to a similar but different condition today, which does in fact chill his conduct because of the violation, which led to him going back to prison for 2 years for violating this condition. The condition he's subject to today applies to sexually explicit material, so raises similar concerns. But Mr. Karlin went back to prison for accessing a magazine that he found through the website of his public library. It was a non-pornographic magazine. The cover of the magazine pictured several males who were nude from behind, and showed their bare buttocks in the cover photo. I believe the magazine also had an article about sex. This magazine, which he did access through the internet, but through his library's website, he could have gotten it in person at his library had he been there, was the basis for the parole violation, which sent him back to prison for 2 years. The lower court erred in at least 3 ways in this case. First, it erred by applying a reasonable relationship standard to Mr. Karlin's challenge, rather than a form of heightened scrutiny, given the First Amendment element of Mr. Karlin's claim.
Is it simply the First Amendment alone, that there's a First Amendment right that triggers a higher level of scrutiny beyond what would be rational?
In this case, yes.
Why
It's
is
the
that?
First Amendment claim that gives rise to that heightened scrutiny. Because the reasonable relationship test effectively looks like rational basis here, but it comes from statutory law, not from common law, and it doesn't
How
account.
does his parole status come into play under your analysis?
The parole status could come into play by perhaps shifting the level of scrutiny from strict scrutiny to intermediate, but applying what the state is arguing is that reasonable relationship applies, basically asking the court to ignore the constitutional element of this case
Well, does the parole
altogether.
status change the level of scrutiny from whatever it is to something else, or does it affect the tailoring of the restriction?
It affects the tailoring of the restriction.
So, well, let me ask it this way. Mr. Karlin, does he have a right to write his congressperson a letter to ask for some law to be changed
Of course,
under the First Amendment?
of course.
And that would be subject to what kind of scrutiny, in your view? Well, let me ask it differently. Is his right in that regard subject to a different level of scrutiny than mine?
You mean if there were a parole condition which restricted his right to
Correct.
write to his congressman?
Correct. And there was a law that restricted mine in the same way. I assume mine would be reviewed under strict scrutiny.
Right, and the court would need to look at, I think strict scrutiny would apply even if there was a parole condition barring Mr. Karlin from writing to his
Would it make a
congressman,
difference
yes.
if he had sent threatening letters to congressmen?
If the parole condition said he can't?
No, if he had been convicted of that, sending
Possibly,
threatening letters
possibly,
to
and it would
members
come-
of Congress.
And that would that affect the level of scrutiny, or would it affect the tailoring? That is, the need for some restriction on him because of what he'd done?
It would come into play with the tailoring. Where the parole condition comes into play, and friend of the court, the New York Civil Liberties Union, sets out how there is support, there's ample support for applying strict scrutiny here.
So in that case, with the conviction for the threatening members of Congress and the condition is you can't write to members of Congress, violated, what level of scrutiny would you get? How would you approach the violation in a constitutional analysis?
If a parole condition said you
Can't write to a
cannot
member
write-
of Congress, and your conviction was for sending threatening communications to members of Congress.
Then I think strict scrutiny, there's support for strict scrutiny applying, and the state would then have to show that this parole condition is the least restrictive means of achieving the government interest of, I assume it would be reducing recidivism, rehabilitation, what have you.
I thought it would be ensuring you don't write any more threatening letters. You can write your congressperson to please put more money into the parks, but you can't write your congressperson that you're going to kill them.
So that would be an example of least restrictive means.
Yes, that's true. Let me ask you, with respect to the condition itself, apart from the issue Judge Singh has raised, an important issue about whether or not it's limited to the use of the computer, is it your position that sexual activity, nudity, or erotic images, each one of those was problematic? Or are
only-
any of those appropriate?
The only two at play for the violations to which Mr. Karlin pleaded guilty are sexual activity and nudity. All of them are broad. All of the condition scope is vast. So each of these on its own would be overbroad in my
Well,
position.
haven't some cases likened the term sexual activity with sexually explicit activity, which has been held to be properly restricted for someone in your client's position?
I'm not, in my mind, sexual activity is much broader than the term sexually explicit. I think the term sexually explicit still raises concerns about
sexual
overbreadth
activity
in this particular case.
Sexual activity connotes sexual acts. Sexually explicit activity, the same. So, I mean, it's really, there's not much of a difference other than the adjective explicit, right?
But there's still a tailoring concern. A PG-13 movie could contain material that is sexually explicit in some
In a PG-13?
individuals.
Is the question of tailoring as relevant if the facts support, this interpretation that sexual activity really means sexually explicit activity? I mean, I only ask because the article that he read here is someone talking about their experience the first time having anal sex, which to me sounds pretty sexually explicit. It's sexual, yes, but it's sexually explicit as well. So, part of me says, regardless of what you called it in the condition, it meets a sexually explicit requirement.
And especially, if I could just add to that, and especially here where the sexually explicit material was related to the history of your client's offenses.
The question before this court, though, is not whether Mr. Karlin's conduct was him viewing sexually explicit activity. There's not a fact question here. The question is a question of law, of whether the condition it satisfies heightened constitutional
So because the
scrutiny.
condition was not properly phrased, as you legally understand it, the underlying activity has no bearing on the analysis. Is that the argument?
Exactly, because the condition is overbroad, because it is not narrowly tailored to government interests. And our position is that even under the government's reasonable relationship standard, when you look at the breadth and the scope of the condition, and you look at the government's purported interests, which, yes, are legitimate interests, but the state articulates no connection between this particular condition.
I'm so interested in why you chose to make this argument with respect to sexual activity as opposed to like maybe nudity. Because nudity could be looking at a Picasso or something like that. But sexual activity, I don't know, it seems very reasonably related to a legitimate penological purpose that's trying to be achieved here. So are you sure that sexual activity is the one that you're focusing on here?
To be clear, we're not focusing on one over the other. And nudity is an easier case, but here, the term sexual activity it's inherently vague, it's incredibly broad.
So what would have been a way to narrow? What, in your view, could have been written here?
So the government the parole board would have had to identify legitimate government interests.
Okay.
And then craft a condition that is.
Okay, but I
narrowly
think you
tailored.
get a sense of what they're trying to do. So how could they have achieved the goal and yet have come up with a condition that, under your rule, under your interpretation, would have survived constitutional scrutiny?
So I won't put myself in the parole officer's shoes because
I know, but I'm
not a-
asking you the hypothetical. How could this condition have been saved?
There are many different ways that it could have been limited. For example, and this would not necessarily have been sufficient, but it could be limited to pornography specifically. That term is inherently vague and raises other concerns, but that would be a way to narrow this condition so that it's not so broad.
Does it matter that the only reason he was subject to this condition is because he asked to use a computer for educational purposes and was afforded that opportunity?
I don't think so, Your Honor. When you look at recent case law, Packingham versus North Carolina, and other case law that's followed, I see my time's
Please
expired.
continue.
Can I finish?
And I have a question for you as well.
The internet, access to the internet has become such a critical part of participating in society. Accessing the internet is a First Amendment right that the Supreme Court and the Second Circuit have emphasized over and over again. So no,
So are you suggesting here no restrictions were allowed for him despite the nature of his conviction?
No, I'm arguing that only narrowly tailored restrictions tied to his internet access or otherwise would be
I
appropriate
want you to
here.
return to Judge Singus's question, because you know, I think both in your briefs and argument have presented your case as if the restriction applies to all of his conduct, even walking through the Metropolitan Museum. Suppose we were to interpret, or suppose the condition itself had clearly read that this is just limited to what he can do on this computer. Would that be sufficiently narrowly tailored?
I don't think so, Your Honor. Again, given that in today's society, we use computers to go to school, we use computers to do work, to
We
read
also do
books,
things
to
like
watch
that.
movies.
He can also go to the public library, he can use his cell phone, presumably, which is not, I don't know if he can have a cell phone, actually.
He can.
Okay, and is there a restriction on that?
But to your,
Do you know if there was a condition on the cell phone?
there are he is subject to conditions related to his smartphone. I believe many of those conditions have been rolled back over
I'm
time.
sorry, I was asking about, not now, but back then. Did he have the same conditions on his smartphone?
I'm not sure whether he was allowed to have a smartphone back in 2018.
okay.
I don't know the answer to that.
Okay. But you would think that even if this was simply limited to the computer, it would still not be sufficiently tailored?
Absolutely, because of the breadth of the types of content that it still applies to. And
So you still are essentially saying they couldn't restrict his use of the computer in any way?
oh, they absolutely could, but they can't restrict him from viewing any depiction of nudity in any magazine
So
or
did it
book or
only have to be
film.
children because those were the victims of his crimes? Is that what you're suggesting? They have to be more specific?
That could be a restriction that might survive the tailoring, but yes, they need to be more
Well,
specific.
that wouldn't, I mean, that, if it was children, it would be a crime. I mean, does it matter that he's on parole for a sex offense versus he's an arsonist or a robber? Does that come into play at all?
I think that comes into play with the narrow tailoring, but not with the fact that the reasonable relationship standard completely ignores the constitutional component.
But the reasonable relationship, he's convicted of serious sex offenses, and the conduct that is impacted is because of that. So but I'm having difficulty grasping what you say, if anything they can do to limit his use of the internet.
To me, there's a difference between, so this condition bars Mr. Karlin from, say, watching The Terminator on Netflix. The iconic opening scene of The Terminator features a nude Arnold Schwarzenegger from behind. Mr. Karlin can't watch that movie under the condition that he challenges. That kind of ban bears no reasonable relationship to his underlying convictions.
So he has to ascertain, like, ratings of movies as to what? The greater difficulty that I'm having here is originally, let me ask you this. Was the original condition that he couldn't use the internet? Was he originally restricted in total?
I believe so.
And then he said, may I use the computer because I have need for educational purposes, correct?
That's correct.
And he was granted that permission subject to certain conditions.
That is correct.
Conditions
But
that he
under-
accepted.
That's correct. But under current federal case law, the landscape has changed around First Amendment rights surrounding access to the internet, even for individuals subject to
I'm
parole
not
and
so certain that
probation.
his access to the internet is completely based on this condition. And I'm not so certain that he couldn't watch Terminator somewhere else, at a friend's house or on his TV. So I think we'll ask for clarification. But if I can, I just have one more question. Should we ascribe any relevance to the fact that his treatment provider said that, you know, he was discharged from his program because of this sexual preoccupation, and they think that this type of material is harmful to his rehabilitation. So if they think that, why isn't it reasonable that his parole officer would think that?
So this came up only after Mr. Karlin was charged with the violations. So it's sort of a bootstrapping.
I don't think so. It was very clear that the report that Judge Singas referred to, the person at the therapy treatment center was very clear that he had violated his treatment program by accessing this material. So, I mean, it happened afterward only because it had to happen afterwards, right? The psychiatrist doesn't have access to his computer, his parole officer does. So the fact that one happens before the other seems irrelevant to me. The issue is whether his participation in the program was terminated because of his violation of their conditions of treatment. It seems to me that that's what the report indicated.
My sense is that the two are inextricably bound up and that it's impossible to separate the two. Again, if his treatment providers could show that imposition of the condition and with its breadth were narrowly tailored to the goals of his rehabilitation, including completing this treatment program, then that would be a different story. But here, the two are so bound up that it's sort of trying to justify the condition after the fact based on the violation itself.
I see nothing in the record that would indicate that the treatment plan was imposed after the fact.
No, but I mean the termination from the treatment program.
Again,
after the violation.
there's no other way that that could have happened, right?
The
The only way they
termination
would
hap-
find, go ahead. I'm
Yes, the
sorry.
termination happens because the information is provided. When they participate in these treatment programs, you agree that they give them conditions in order to stay in good standing in the program, correct?
That's correct.
And if they receive information that they're not in compliance with those very same conditions, then they can be removed.
That's correct.
So the only way that, as Judge said, he could be removed was for that information to be relayed, but it couldn't be relayed other than the provider getting it from the parole officer or someone else who had access to his computer.
But I'm not sure that the condition being challenged here is coterminous with any condition of the treatment program.
But it's the
And-
conduct. The conduct here was the same trigger for the treatment program decision. It wasn't the fact of a parole violation that triggered that, it was the conduct. Conduct's reported to treatment folks, they say this is a violation, right? Because you violated our own terms of what we think is, would hinder your rehabilitation. Isn't that right?
The charge for not completing the sex offender treatment program is not a charge that Mr. Karlin pleaded guilty to, so it's not part of this appeal. Your point is taken, Your Honor, that the underlying conduct may have violated the terms of the treatment program, but that doesn't change the fact that the condition Mr. Karlin is challenging merits heightened constitutional scrutiny.
Can I just clarify, because you said before, I think you said before, that he already had a condition imposed upon him that he could not access the internet, or did I misunderstand you?
I believe that's true.
Okay, just to be clear then. But he's not challenging that. Is that correct?
Well, because he got access to a computer and the internet. So he's not currently subject to, back in 2018 when this violation occurred.
No, I take you to be saying that that request to use a computer for educational purposes is functionally equivalent to saying, please let me have general access to the internet.
My understanding is that
And that's the way he understood it.
My understanding is that his internet access and access to a computer was not conditioned on, but you can only use the internet for educational purposes.
Would that have been a legitimate, I was going to ask your adversary that very question, but since you said it, I'll ask you. If he had asked for access to a computer to do his education, and the condition the parole people put on letting him have a computer was, you can use it for educational purposes at your university website, and for nothing else at all. Can't stream HBO, because sometimes that has nudity on it. Can't go on TikTok, none of that. Would that have been a legitimate condition of parole?
I don't think so, Your Honor.
Why?
Under current First Amendment case law, the rights of parolees, individuals on probation, to access the internet for purposes beyond just educational purposes, but also for certain social and entertainment purposes has,
So if they give him access for purposes of the stated reason that he wanted the access, but they restrict him for any reason that's not connected to that, they've violated his First Amendment rights.
well, you'd have to engage in a First Amendment analysis.
Okay, he
but
can't
yes.
watch HBO, he can't stream HBO. That's a violation of his First Amendment rights.
So that would be much narrower than the condition we're dealing with here. I think it would still raise concerns about narrow tailoring. But a blanket ban on his use of the internet for anything other than educational purposes would almost certainly fail First Amendment. Not to say that total internet ban would be inappropriate in every situation for every individual, but just that it has to meet that heightened scrutiny. And the reasonable relationship test doesn't take these constitutional considerations into account whatsoever.
Thank you.
Thank you.
Good afternoon, Your Honors. Kate Neveu for Respondent. Your Honors, I have to start by clarifying that the condition at issue is both broader and narrower than the court's talking about. It is not a condition that's based on the internet, only applies to internet use, because the special condition was something that petitioner's parole officer determined was necessary to protect the public from petitioner's high risk of reoffending as a serial sex offender, an abuser of children. So if it were limited to just the internet, it wouldn't protect.
I just wanted to understand with particularity what that means. So did it apply to his activities that were not online activities at all?
That's correct.
So walking through the museum, he can't see nudity?
No, that's not correct,
Okay,
Your
so
Honor.
then you got to explain a little
Yes,
more.
Sure. The charge, nudity here is sexual nudity.
I
The
wasn't
charge,
asking about, sorry, I wasn't asking about nudity for the
Sorry.
moment. I'm asking about what media or activities it applies to.
sure. All media, all activities, because the purpose of the special condition is to reduce petitioner's access to stimulation of his sexual impulses, because his inability.
And why is it imposed when he asks for a computer? If that's the goal, why isn't it imposed right
Previously,
away?
he had been under a slightly different condition.
Which
Your Honor,
was?
Which was that he could not have purchased, possess, or engage in any way with the use of any sexually explicit materials or erotic magazines, tapes, blah, blah, blah. So it's not as
Is
though,
that in the record anywhere, or we don't have that in the record?
it's quoted in petitioner's reply brief, Your Honor. No, excuse me. That's his current condition, which is quoted in his reply brief. He mentions in his, yes, it is in the record, he states in his petition, previously, the condition I was under was that I couldn't have access, I couldn't engage with sexually explicit or erotic materials.
So what about getting the computer then?
That's not clear to me why there was a shift. It may be that there was a shift in the parole officer. It may be that that happened
I
to
don't
be.
think it was a shift. I mean, I'm looking at the document A38, and it's basically special conditions 1 through 8, which all have to do with the computer. And I think it was prompted when he asked for a computer.
Right, but he had
And they added these conditions, because now he has a computer.
Right, so what it is the last condition replaced the prior condition, which was about said sexually explicit or erotic. We regard these as basically equivalent. And part of the reason that the reasonably related standard is appropriate here, as opposed to the heightened scrutiny that petitioner is arguing.
Going back to nudity for just a second,
Yes.
did you answer the Chief Judge's question about why walking through a museum wouldn't create a violation of the nudity?
The
requirement?
condition is interpreted by Doxson as was charged as sexual nudity, Your Honor.
What is that?
It's nudity that, it's not just walking past a statue, and it's also, the condition was view, access, download, or I forget what the last verb is.
Well, I mean,
View,
there's some
view, access, possess, or download, and so those, you have to read view in context, Your Honor, with the rest of those as affirmatively seeking out and engaging the depictions of sexual activity and
What
sexual.
about Titian's painting of the Rape of Europa?
I'm not familiar with that. I'm going to take your word that it,
It's in the
But-
Isabella Stewart Gardner Museum.
Sure.
It's from Ovid, it's from Metamorphoses. Presumably, he can't read Ovid either.
well, the question here is,
No, I'm not actually being facetious.
no, I understand that, Your Honor.
That is sexual activity. It's painted several hundred years
And
ago. It's from a
because-
story from 2,000-plus years ago.
Sure. The question here is that this condition was imposed because petitioner's crimes, to put it at a minimum, involve, you could call it a failure to restrain his sexual impulses. So the condition is meant to limit stimulation of petitioner's sexual impulses. That is a judgment that was made based on his crimes of conviction, based on his need for rehabilitation.
So if I'm understanding you, these triggers that they've determined, right, fall within sexual nudity, sexual activity, and so forth.
Yes,
The condition that applied to him was anywhere you see this, whether it's in a museum, on a poster, it doesn't matter. Anywhere you see this. Is that correct?
no, because
Okay.
you have to be seeking out, or suppose, for instance, you're.
Going
That-
to a
is that what the
museum is
condition
not
said?
seeking out?
Is that what the condition says?
It says, view, access, possess, or download. So you need to read view, not in, it crosses my eyeballs, but view as in, similarly to access, possess, or download, it's crossed my eyeballs and I've stopped.
So when he's
Engaging
walking
with
through the
it.
museum,
Yes.
he's got to cover his eyeballs as he walks by
No,
this
but if he,
particular painting?
no,
But
but
if he
if he's.
stops and looks at it, then it's a violation.
Yes. Because
So this
that-
I mean, look,
particular,
I think-
this,
I think there's a difference between Titian's rendition of a rape scene and maybe the David, Michelangelo's David or Venus de Milo. So would that kind of context be taken into account?
Yes, these are, and that's one of the reasons why the reasonably related standard is important, is because we're talking about highly
Okay, so where is that set
fact-specific-
out in the condition? That all sounds like an interesting way to perhaps limitations and contextualize and so forth, but it's got to be in the condition. So where is that?
He was charged with access to sexual nudity.
No, I'm not talking about the charge. I'm talking about the
Yes.
condition that he
That
would
demonst-
read and he would understand.
He's never argued that that the condition was unconstitutionally vague, Your Honor, which is what I think your argument is getting, your question is getting at. He never argued
He's
that,
argued it's, you're right, he hasn't argued vagueness, he's argued it's unconstitutionally broad.
right. And that argument requires that he be actually chilled, which he has never argued, except
don't
before this court,
think
that
that-
he was chilled.
I don't think that's right.
Yes, Your Honor, the question is it going, you have to be substantial, it has to encompass substantially more conduct than is constitutional. And if something, we're using the reasonably related standard, which is the appropriate standard, because we're talking about administrative judgments
But if he
that require.
can't read Ovid, it seems like that's substantially more than what's required, unless you think there's a reason that he can't read Ovid.
Your Honor, I'm going to note, first of all, that he's not subject to that. The condition he's currently subject to.
Right, but we're talking about the condition he
Yes,
was
I
subject
just
to.
want to, but the reason I'm clarifying that is because it demonstrates that this is a condition, petitioner suggested below that this is a statewide condition or a condition that applies to thousands of people. We can see that even within this record, that the conditions vary, that they vary by the parole officer, they vary by, and so the argument that there's substantial overbreadth has to also looks to the chilling effect, not just to petitioner, and there's no chilling effect on petitioner. He's only argued in both his petition and the appellate division. He never argued he changed his behavior. He's only arguing that now. So the court, I think, can take that fairly into consideration in arguing that his prior condition, the one we're challenging, did not actually chill his behavior.
You
And that
you
there's no
continually use the phrase sexual nudity, but I don't see sexual in front of nudity anywhere in the condition. And it seems to me that changes what we're thinking about.
That's correct, Your Honor. I can say first is that's how docs interpreted it. If petitioner had spoken to his parole officer at the time, that's what he would have been told. It's not part of his current condition. And again, petitioners never argued that there's a vagueness.
it's an
to the-
overbreath. With respect to chilling, to get back to where you were, you talked about chilling him. Does there also need to be a chilling effect to the community at large when you're looking at a provision like this?
Precisely, and because this condition doesn't apply to the general public, it also
The
doesn't.
museum can still show the rape of Europa, and the Uffizi can still have a statue of David, I assume.
Yes.
Is that right?
Yes, Your Honor.
And the library computer can still have Q Magazine with all its pictures and articles in it. He just can't look at them.
Right, and that's because his parole officer made a judgment based on his expertise, based on the individual facts of the case, that this was something that would harm petitioner's efforts at rehabilitation and the public safety.
Don't we need
Given-
more than just the parole officer?
I'm sorry, I'm not sure.
Don't we need more evidence that there is a correlation between viewing these materials and a heightened risk of reoffending?
No, Your Honor, but if you did, you have it because of the discharge from the sex offender program that was mentioned previously. And that was not, and I realize that, this material was submitted in camera, so I'm not criticizing petitioner's counsel for not having seen it, but the specific material, both accessing the material was a violation of his conditions of treatment and showed that he was not cooperating with treatment. The specific material also made him more likely to reoffend, as was described in the in-camera material. And also, petitioner didn't disclose that he accessed these materials in his treatment so that they could be addressed. So it was reasonably related. The parole officer was tracking the concerns raised by the sex offender treatment program here, and determining that this condition was reasonably related.
I still am having trouble understanding how you would, even under a reasonably related standard, you would say that a prohibition on his reading something that is a depiction of nudity is reasonably related.
Because
I mean, there are 4 references to nudity in Genesis.
the question, Your Honor, is that, the reason is that petitioner sexually abused multiple children over
No, I get that he did
several years
something
because he
bad.
couldn't control his harmful sexual impulses. And the judgment was that in order to further his rehabilitation and to protect the public, that he needed to have his stimulation of his sexual impulses limited by not letting him access sexually
And the question,
material.
but the question is whether the definition of the condition is reasonably related to that or is much more than what is needed for that.
Right, and it's reasonably related because he showed that he couldn't previously control his harmful sexual impulses,
Well,
limiting.
his original condition was substantively a lot narrower, right? I think you just read it to us.
Sexually explicit or erotic.
Yeah,
Your Honor.
what was wrong with that?
Nothing, but there's nothing wrong with this either. And this kind of going back and forth between.
Well, so what if it just said he can't read anything?
That would be overbroad, Your Honor, because that's not reasonably related. The problem here is petitioner's sexual impulses. These conditions were related to those sexual impulses. And going back and forth as to pornography versus sexually explicit versus sexual activity, Your Honor, reducing someone's likelihood of reoffending, it's not an exact science. We can't run an ethical double-blind study as to whether, this term or that term or the other term would be sufficient, especially since we're talking about individual people and not just blanket considerations. We're talking about a parolee by parolee determination.
But
Making that kind of
I took
judgment-
your argument to be that nudity must be interpreted as sexual nudity, whatever that means.
Yes, that's correct, Your Honor. But the argument as to
What does the sexual do for the word nudity? What is it clarifying there?
It's clarifying that it's depictions that
Okay.
involve, the sexual impulses that are being attempted to be.
Isn't that
Different
an
from
incredibly-
sexual activity. Is that,
sorry, could you say
there's
that?
a distinction or the parole officer is drawing between sexual activity, representations, materials associated therewith, and sexual nudity. Is that correct?
That's correct, Your Honor, yes, because the two categories are not fully overlapping.
That sexual nudity phrase troubles me because it seems very subjective to me. If we're talking about the realm of all nudity, what inspires some sort of sexual response, to me seems like a very particularized kind of inquiry, especially with a person who's a sex offender, and I think you said his particular proclivity was abuse of children. So I'm not sure whether David or Titian's painting would spark any sort of sexual response in him, but
There's two
something else might.
There's two responses to that, Your Honor. One is, that's a vagueness argument, and petitioner's not making that.
Okay.
And two, this kind of individualized discussion is exactly why the determinations of the parole officer who speaks with petitioner, who's on the ground, who's making these judgment calls based
Well,
on
is
their
it really a
professional
vagueness? Is it
expertise,
solely a-
require a reasonably related
Counsel, is
standard.
this solely a vagueness argument? If you're saying you're including, I think part of the questioning was that this is including images of adults, when that is not necessarily what triggered the crimes, his interest in adults, right? His interest in children.
He's been very clear in his treatment that his proclivity is to young males. So how would restricting viewing a statute of a naked woman, how could that possibly be tied to a legitimate penological interest here?
It's possible that the statue of the naked woman wouldn't be sexual nudity, and that's not what he pled, because that's not what he pled guilty to, so that
How is
question
not-
wasn't
wait a minute,
explored.
Wait a minute, how is that not sexual nudity? Now I've lost you completely.
The question is it,
In terms of the way the condition is,
Yeah.
I'm
Yeah.
granting you for a moment that even though the word sexual is not placed before the word nudity, that somehow we should read it that way, but how is a portrait, a statue, whatever you want to say, of a nude woman is not sexual nudity?
there's two ways that that could be addressed. One is the context, if it was, designed to be sexually stimulating. In this case, we have, the photograph was was the cover of a magazine that included explicit sexual contact, which makes, context, both in this case, that makes it sexual nudity. The other is what would be viewed as sexual to the individual parolee, which is why I
Yeah,
was
but I think that was
suggesting
the question being asked.
Right, and that's why I was suggesting that perhaps if petitioner has zero attraction to women, that perhaps a statue of a woman would not count,
So
How
are
is
you,
it not overbroad as a consequence?
because it's the question of what's
It's not a
sexual.
trigger,
That's
and why is
because,
it prohibited then?
I said it might not, what I'm trying to say is it might not be because it might not count as sexual nudity.
so are you
Is that-
saying that although there is verbiage describing the things that are prohibited, as to whether or not one violated the conditions, context is considered?
Yes, and because it's, the parole officer is making the, and also, it's important to note that petitioner could always speak
How
to.
does he know that in advance?
He could speak to his parole officer,
Can I go look at a picture of a nude woman?
Yes.
You mean?
yes. Also, I'd just like to note that there is an administrative process to challenge conditions, so it's not as though petitioner can only find out what's prohibited by getting arrested for it. I would just like to add extraordinary.
Except that, I'm having trouble with that, because it seems to me that how can he anticipate what he's going to come across in order to get a pre-approval to something he doesn't even know he's going to see? So
Right,
it
that's-
seems to me that it's creating a requirement that is impossible for him to meet.
And that's why the view, it's not just whatever your eyeballs come across. That's not the kind of conduct that's of concern. It's viewing in a way that's sitting there and looking at it, that's actively engaging with it in a similar way to access, possessing, and downloading. It's not meant to be a trap. It's meant to be a way to further petitioner's rehabilitation and to protect the public.
How do you know how long he viewed the cover of the magazine?
There's not a question, petitioner didn't challenge that it was sexual nudity, Your Honor.
No, but you said if he just looked at it and moved on, that's not viewing. He has to really be gazing at it. How do we know what he did?
Well, he sought out this particular magazine, he downloaded it, and so he never disputed that this counted, Your Honor.
Well, he
So-
pled guilty, but that may be because he didn't view the way you're arguing it means now.
He hasn't raised that argument at all, ever, Your Honor. And so
And
that,
has he,
like
in
petitioners.
the litigation prior to this argument today, have you ever taken the position that view doesn't include just seeing something, but you have to dwell on it?
He hasn't argued,
I'm
he hasn't
asking-
raised
I'm
that
asking-
argument for us to raise it.
Okay, so it hasn't come up before?
No, it hasn't come up
Okay.
at all.
Have
It's in
you
the
ever
same-
explained, or anybody in this litigation prior to you on your side of things, explained that interpretation of view?
No, because it hasn't come up.
Okay.
In the same way that petitioner's argument now for intermediate scrutiny had not come up before before petitioner arrived in this court. I would just like to very briefly, if I may, Your Honor, say that strict scrutiny, which amicus has argued for, is absolutely inappropriate because it requires that a restriction be the least restrictive alternative, which poses an enormous administrative
Is strict
burden.
scrutiny even preserved in this case?
It actually is.
It is?
Petitioner argued below that this was an overbroad argument, overbroad restriction because strict scrutiny applied. So that is actually all petitioner argued before he got to this court.
And now they're arguing intermediate. So I guess that raises the other, is intermediate scrutiny
Preserved?
preserved?
No, absolutely not, Your Honor. And so that shouldn't even be decided by this court. But strict scrutiny would pose an enormous administrative burden to explain why individual decisions as to individual parolees are the least restrictive, and therefore the suggestion of amicus and a petitioner below should be rejected. Unless the court has further questions, we ask that the decision be affirmed.
Thank you.
Thank you, Your Honors.
Have you abandoned your strict scrutiny argument?
Our position and appellant's position all along has been that heightened scrutiny applies here. The question before the court is whether the condition is unconstitutional under the First Amendment. And throughout this proceeding, the courts have been able to consider the entire spectrum of scrutiny from reasonable basis, reasonable relationship, whatever that means, rational basis, all the way to strict scrutiny.
And he was pro se when he filed the petition.
That's correct. That's correct. So below, appellant argued for strict scrutiny. We believe that there is support, as the NYCLU points out, for applying strict scrutiny here. However, intermediate scrutiny is the bare minimum required here to account for the constitutional interests at stake.
Counsel, do you agree with your opposing counsel's characterization of this condition as general rather than tailored to the computer, and that it somehow replaced or is a complement to some earlier condition?
Mr. Karlin's understanding of the condition is that it applied to anything digital or not digital. That's correct. I will say this is the first that I've heard that the term view in the condition means that he has to actually seek out nudity or sexual activity, particularly when we're talking about online content, or say you go to a used book sale and you pick up a bunch of novels that look interesting. You now have those materials in your possession. If you flip through it and you see a picture you're not supposed to see, you viewed that. Did you seek it out because you sought out the magazine but didn't necessarily know what would be inside the magazine?
Would it be different if you went to a bookstore or used bookstore that specialized in the explicit items that he was told he was prohibited from seeing? So he knew it was more likely that he was going to see those things?
I think that would be different if the condition was limited to seeking out this information, but the condition is so much broader than that as it's written. It just says view, access, possess. So I don't think it would make a difference under this broad condition that Mr. Karlin challenges.
Would it be fair to imply an intent element to that?
Could you repeat your question?
Yeah, would it be fair to imply at least some element of intent into view, possess, et cetera, that, you know, if he's walking down the street and I take some, you know, piece of pornography and thrust it in front of his face, that we're not going to, nobody would think to hold him liable there.
As the condition is currently written, though, I don't think there is an intent element. That could be one way to narrow it, when we're talking about the
But I
practicalities
guess
of
I'm
how it
asking,
might be
isn't that sort of
enforced.
fair to imply? Because we generally, when we think of crimes at least, we think of them as having
Right.
some mens rea requirement.
That's right, but the way the condition is drafted is not,
So the
narrow
way
in that
you're
way.
suggesting the condition in Buffalo, New York, on the Scotchequota Expressway, there is a statute of David. If he drove by, he would violate the conditions of his parole just by driving by, even though he had no idea that that statute was there, because he's from downstate.
that's correct, Your Honor, and that helps illustrate why this condition is just so overbroad as it was drafted. There's no chilling effect requirement to prevail on an overbreadth claim. Just the fact that there are so many applications of it which clearly fall outside any legitimate scope of the condition is enough for Mr. Karlin to prevail.
But in context, that condition does, one would read that as volitional.
Viewing,
Yeah, well, it's view, access, possess, and/or download.
I don't think it's drafted in a way that provides for that narrowing. It should be
To view, you think, is not about a
to
volitional
possess,
act?
because you can possess material without necessarily knowing everything that's inside of it. You could start watching a movie and you didn't know that there were, what the movie entailed. So the
That seems to
condition,
be veering into vagueness a little bit, though, doesn't it?
overbreadth and vagueness are
Yeah, they really are.
very overlapping, very much overlapping, although
So
it is an
you don't
overbreadth
read the,
claim
you don't
punishment.
read the condition to put the burden on him to determine, in these examples you give me, looking at a magazine, viewing a movie, to find out in advance whether or not there are depictions, images that would fall within the condition.
Correct, that's not reasonable to put that burden on.
Why not? Why not?
Because as a parolee, I think it raises tailoring concerns.
Find
and
out
it-
in advance, I think you were saying before that pornography would clearly fall within. I shouldn't find out in advance that a movie I want to rent is a pornographic film?
So I think there's a difference between that question. If you're ordering a pay-per-view movie from, Channel XXX
Yeah.
versus if you're going to a used bookstore and.
But we don't
picking up-
even have to go that far here, right? I mean, here your client downloaded Nymphomaniacs.
He
The,
watched-
the title of that movie by itself puts him on notice that this is a sexual film.
A couple points in response, if I may. The movie is a film available on Netflix. It made the rounds in the film festivals. It won a bunch of awards in Europe. This
Many
wasn't-
award-winning films have sexual activity and sexual nudity, right?
Exactly. And Mr. Karlin did not plead guilty to the charge that was related to that movie, so I'll point out that that's not part of this appeal.
I don't know about that.
Separately, though, the question isn't whether this movie fell under the condition as drafted. It's whether the condition is so
Well, I think we can all
broad.
agree that it absolutely fell within the definition of the condition.
Right, but that's
I mean,
not-
that's not even up for debate. Can we agree on that?
Correct, we can
Okay.
agree on that, although it's not part of this appeal. Mr. Karlin didn't plead guilty to that particular violation. But the question before this court is whether the condition and everything it encompasses is substantially overbroad, is whether the condition is narrowly tailored to important government interests, which it's not here. So for that reason, we would ask.
On that film, you would make that argument? I don't think that argument can be made with the history of your client and that film.
But the challenge isn't limited to this film. The court must look at everything that the condition encompasses, not just these specific examples.
You concede that nudity is sexual nudity.
No, not necessarily. No, that's not clear. The charge to which Mr. Karlin pleaded guilty did use the term sexual nudity, but from the condition itself, it's very unclear. Because then the condition doesn't quite make sense then if it's sexual activity, the language is sexual activity, nudity, or erotic images. So if sexual modified all three of those, like
What-
sexual erotic images doesn't,
What nudity falls out of the category of sexual nudity?
I'm not quite sure. I don't.
Perhaps some baby
It does
pictures?
something, it could conceivably narrow it in some way, but then we run into vagueness issues. But that's not how the condition was drafted.
Thank you.
Thank you.